Big news yesterday coming out of Washington, D.C. There was a major Supreme Court decision, and then that was blown out of the water when Kennedy announced that he was resigning, and the attention to the actual case got sort of drowned out. But Dan DeSalvo joins us, senior fellow at the Public Employee Unions at the Manhattan Institute, joins us. Good morning, Dan.
My pleasure to be with you.
So the Janus case, as you will, a 5-4 decision that went against the unions. Your initial thoughts, what's going to happen now because of this ruling?
Well, it's really a landmark ruling that portends to potentially weaken public employee unions by allowing people to get out of unions and not pay them if they don't want to, so they could lose some members and money in the years ahead.
And the argument was for the majority, hey, I work for the state, but I shouldn't be forced to pay union dues.
Well, the argument was on the basis of free speech and freedom of association. If I want to take a job in government, I shouldn't be forced to pay into a highly political organization as a condition of employment.
Sounds fair. What's the problem?
Well, the problem from the union's point of view is, well, you're going to get benefits that the union's going to provide, and then you won't be paying for them, and you'll essentially be a free rider, and therefore that's bad for us.
Yeah.
So it set up a conflict between free rider and free speech.
I heard somebody say yesterday that this basically turns all government union jobs into a right-to-work state. Does that make sense?
It does make sense. Basically, right to work means you can't be forced to pay into union coffers if you don't want to. And that's the situation in the federal government and in 28 states.
Yeah. Okay.
And now in the public sector across the country.
Okay, so now does this mean that a police officer doesn't have to join the police union, a firefighter doesn't have to join the firefighter union, and a teacher doesn't have to join the teachers union?
Well, it was always the case that you couldn't be forced to join the union because that would violate your First Amendment rights to freedom of association. Now you can not be forced to pay the union. Before that was the case that even if you couldn't be forced to be a member, you could be forced to pay. No longer can you be forced to pay.
So if you're not in the union and you don't pay, then you still get the union benefits?
That's because the union wants to represent, and it has another legal right called exclusive representation, that it wants to bargain, be the sole monopoly bargaining agent for all workers. So any contract they negotiate, it'll cover everybody, whether they're members or whether they pay dues or not.
So what's look in your crystal ball 5, 10, 15, 20 years from now? What happens to public sector unions because of this rule?
You probably see some declines in membership. The estimates are pretty broad, ranging from 5% declines and some at the low end to 30% declines at the high end, probably somewhere in between. But lots can happen. So states could pass new laws that could help unions organize and so on. So it's really hard to see too far into the future, but some weakening of public sector unions seems like the most likely outcome.
Yeah, I still don't understand, Dan, the benefit they're going to get the benefits of the collective bargaining, the pensions or whatever else, but they don't have to pay any of the dues. It sounds like the unions have to represent these people, and these people don't have to pay them.
Well, the unions want to represent everyone. The right or privilege of exclusive representation is a powerful one. It basically means that no one else can negotiate with management except the union, meaning you can't bring in other unions, you can't individually negotiate with management. So unions are going to be very reluctant to give up on that power, even if they don't have everybody forced to pay in.
Right, but the idea is that the union is going to get you some type of benefit, right, whether you're a school teacher or a firefighter or whatever else. And so you're going to benefit from their perceived benefit of a negotiation, right, because they wouldn't negotiate down. And yet you don't have to pay to help them administer all of that work.
That's right. And the Supreme Court's argument, you know, if you take a look at Justice Alito's majority opinion, right out of the gates, he says these kind of free rider arguments are insufficient to overcome the First Amendment concerns or First Amendment violations, meaning, yes, that would be better for the unions. Some people might get, in a sense, something for nothing, but you can't force people then to subsidize political activity with which they disagree.
Yeah, interesting. Dan DeSalvo, Senior Fellow on Public Employee Unions at the Manhattan Institute. Dan, thanks for checking in. Good stuff.